everyone's attention, and please come in the room. This is going to be a great panel with a very relevant and timely discussion around Section 230, what it means to our economy, free expression, and all the things that have come out of the internet age, rooted back in the 1996 Telecommunications Act. The debate is always current, and the expertise and the leadership of the indefatigable Rob McDowell. Thank you.
Thank you, Congressman. Chip and I have known each other a very long time. We were born the same summer, 39 years ago. And anyway, I used to lobby him when I was with COPTEL, which is now INCOMPAS. And then by some miracle, I got appointed to the FCC. Then he was my overseer. And sometimes he asked really tough questions of me at oversight hearings, which is good. I always appreciate it. And so you're in great hands, INCOMPAS. All right, we do have a great panel today. So Section 230, for those of you who don't know what it is or how it affects your lives, we're going to explore that a little bit. We don't necessarily have a lot of contrasting views regarding 230. So I'm going to at times play devil's advocate. I'm going to channel Brendan Carr and some others, maybe Senator Hawley and some others, to try to give you some conflict and counterpoint type stuff. So what I'd like to do first, though, is, and Barron made the mistake of sitting next to me, is to kind of go down, have each person say who you work with, what do you do, something about yourself as your own introduction, rather than the usual moderator droning on with an introduction. So, Barron.
Barron Soka.
Oh, sorry, I got to turn on the mic.
Sorry,
yeah.
It's on now, yeah?
Yes.
Barron Soka, Tech Freedom. I've known Rob for 15 years, something like that. And I would just encourage everyone to get out of DC for your own mental health, as I've done.
Hi, I'm Josh Wither. I'm a fellow with the Tech and Innovation Policy team at the R Street Institute.
Hi, everyone. My name is Amy Boss. I'm the Director of State and Federal Affairs at NetChoice. Been with NetChoice for about 3 years and spent about 16 years working on Capitol Hill as well. I think that's where I met you first, Barron.
And my name is Jeff Wessling, and I am the Director of Tech and Innovation Policy at the American Action Forum. And a little fun anecdote is I was an intern at Hogan Lovells during law school. So I'm coming back to the office that I spent a lot of time stressing out at.
Great. So we could go into a preamble. We're starting a few minutes late, and we only have 40 minutes now left, I think. So jump ball, little improvisational theater here. Who would like to explain what Section 230 is and what does it do?
Yeah, well, it's the law that made the internet possible. I mean, it would not be possible to offer services that offer user-generated content if you had to face the full weight of the American legal system. So Section 230 does primarily two things, although it's a little more complicated than that. Number one, it offers a procedural shortcut that allows you to vindicate your First Amendment rights in court when you are sued for content moderation, thing that you have a clear First Amendment right to do. If you are a provider of an interactive computer service, the court has said repeatedly, it just said again last year in the NetChoice cases, that you have a right to curate content just as newspapers and parade organizers do. But having to vindicate that right would actually be extremely costly. Section 230 offers you just a procedural shortcut to say that you don't have to do that in every case. You can easily dismiss those lawsuits with a motion to dismiss, and you can avoid facing the death by 10,000 duck bites that you would otherwise face. That's one thing. And the second thing, which is more commonly thought of, is that Section 230 short circuits and overrules the way that the courts were starting to develop the common law of liability for user-generated content, whereby you, as a provider of an interactive computer service, could have been held liable if someone had told you or if you had monitored your service and you thought maybe there was reason, someone could allege that you had reason to think that some of the service, some of the content that you were hosting might be unlawful, you could have been lawful for that, which would create, of course, a terribly perverse incentive for you not to moderate content, not to have any idea what was going on your service. So in that sense, Section 230 changed the common law, and for the better. And in a nutshell, Congress recognized that it would not be possible to host user-generated content at scale, the scale of the internet, which even then was something that could not have been managed in the same way that newspapers manage things. I mean, the op-ed page of the Washington Post or the New York Times publishes something like 3 to 5 op-eds per day. And of course, major services today host literally trillions of pieces of user content. There's simply no way to screen that in the way that content is pre-screened for traditional publications. So Section 230, as Jeff Kossoff has said, really is the law that made the internet possible.
I think, and just in the basics, most simple terms, it's about personal responsibility too, right? Platforms aren't responsible for what individual users say. Users are, and I think just as important as it is to describe what Section 230 is, it's also very important to describe what it is not and what it does not cover. I think there's a lot of myths about Section 230, what it does and what it doesn't do. It's not a special privilege just for big tech companies. There are exceptions to Section 230 as well. It doesn't cover intellectual property rights, federal criminal law. So I think dispelling some of those myths is really important in the conversation as well.
Anybody else?
I just would add to that, also, of course, protects users. So President Trump, of course, invoked Section 230 when he was sued for retweeting someone else's defamation and had that suit dismissed. So Section 230C1 applies to the provider or user of an interactive computer service. And it also doesn't protect you if you are responsible for the development, even in part, of content. So it really is only for content that is created by third parties exclusively.
Okay, so is it safe to say, as an oversimplification, it's a liability shield for exercising content moderation?
Well, so that's one of the two functions, right? To simplify a little bit, because there's some other things here, but C1 says that a provider or user of an interactive computer service may not be treated as the publisher or speaker of content provided, created in whole or in part by another information content provider. And that has been interpreted by the courts to cover the functions of publishers, which include both hosting and organizing and curating content. So right there, that is both the hosting of the content and what we call today content moderation, but also curation and algorithms. That's how the courts have interpreted Section 230, right up until the exceptional case of Anderson versus TikTok, where the Third Circuit clearly garbled the statute. We could talk about why they did that, but they effectively said that curation of content is not a publisher function, which is of course ridiculous. It's plain on the face of the text that one of the things that publishers do is curate content. The Supreme Court has said that repeatedly. The Third Circuit sort of tied itself into knots and got that wrong.
So let's use that as we're getting harmful interference, I think, in 600 megahertz. Anyway, a battery issue, I believe. We'll put it down here. Thank you, Baron. FCC, let's just jump right to the FCC. All right. So October of 2020, the Ajit Pai FCC's general counsel, Tom Johnson, now a partner at Wiley Ryan, wrote a memo outlining, and one could argue under pressure from the first Trump administration, outlining why the FCC had, thank you, rulemaking authority effectively under Section 230. So for those playing at home, Section 230 starts with the number 2, and that means it's housed in Title II of the Communications Act of 1934, but through the Telecommunications Act of 1996, but they called it the Communications Decency Act. Chip, did you write Section 230? No. John Windhausen's also disavowing it. So John Windhausen. I see. That was Senator, or he was then House member Wyden, right? Yeah. And Chris Cox. Okay. It was a House-driven thing, though.
Senate was the Children's Decency Act, and the House.
I'm getting there. Just a minute. You're not the moderator. Put your mic down. So, we'll get there. Okay.
Classic compromise.
You want to get a chair and a mic and just come on up here? So, no, it'd be really good to have this. No. You were there.
That's basically right. I mean,
Close call, Congressman.
The short version is that there was the Communications Decency Act in the Senate made it a crime to transmit obscene and indecent content to minors and would have required the FCC to be the censor of the internet. And in the House, Watson and Cox put forward their Internet Freedom and Family Empowerment, if I recall correctly, Act. And those two things got married together in the Communications Decency Act title of the Telecommunications Act of 1996. The Supreme Court in Reno versus ACLU struck down essentially all of the Senate bill, the Communications Decency Act, leaving in place only effectively Section 230. So it's very confusing and misleading when people call it Section 230 of the Communications Decency Act. That's not technically right. And it also, it just misses that was a separate thing that was intended to keep the FCC out of censorship and to remove disincentives for content moderation. That's all that's left standing. But the Trump administration in 2020, when they were mad about Trump being fact-checked by Twitter, went on the warpath against content moderation, including fact-checking and content labeling, which is just incidentally, content labels are not covered by 230 because they're your own content, right? So really what the administration was trying to do is to break content moderation, like suppressing, for example, if someone lied about who was going to win the upcoming election or whether it was going to be stolen from them, or continued lying for years afterward about who actually won the 2020 election. And hypothetically, if someone did that and they were the president and social media networks decided to block that content or reduce its visibility or even remove that person after they tried to incite a coup, hypothetically, those things would be, protected by both the First Amendment and Section 230. And the Trump administration essentially asked the FCC to rewrite Section 230 in order to make content moderation no longer of that kind, no longer be protected by 230.
I'm going to do some content moderation here. So October 2020, Tom Johnson writes a memo saying the FCC effectively has rulemaking authority. So I'm looking at Amy. I'm gonna have her talk now. And Amy, tell me about that, and also vis-a-vis. So there's a lot of legislation which Barron thinks is terrible and poorly written, which is I want to hear about that in a few minutes. Not yet. So to amend Section 230C2A for those playing at home. Do we get CLE credit for this? So to restrict content that is, quote, obscene, lewd, lascivious, filthy, excessively violent, or harassing. So that would be the only immunity platforms would have. That, when you look at the Project 2025 chapter on this, written by Brendan Carr, is effectively what he's saying, was my interpretation. So I want Amy to comment about that. And then, at a degree of difficulty, the Tom Johnson memo, October 2020, relies on Chevron deference, 1984 Supreme Court doctrine. That was overturned last summer by the Loper-Bright decision, saying the courts do not have to give agencies deference for interpretation of their own statutes. So if that memo relied heavily on Loper-Bright, and then this would be a jump ball for everybody. But I want to hear from Josh and Jeffrey too. Jeffrey, you've been completely like the Sphinx, and I know that oxygen's been consumed. But what are the appellate prospects for either a declaratory ruling or rulemaking? That's a lot. Go, Amy, go.
Okay. Well, first, in regards to what authority the FCC may have to interpret Section 230, I think the Supreme Court has been crystal clear that courts and not the administrative state has to interpret statute. And I think Loper-Bright throws another wrench into that. And even I would throw in the major questions doctrine as well. I think their ability is extremely limited, if they have any ability, just to be frank. I'm happy to kind of jump into the legislation that you mentioned, but I don't know if others want to talk specifically about FCC.
I know you're not a lawyer, but on that point, I just want to pick up, and just go ahead and practice law. Don't worry about it. So in 1998, when I was at CompTel, the Supreme Court handed down the Iowa Utilities Board case, which I'm going to paraphrase, basically said the FCC has general plenary rulemaking authority under Title II. So if something starts with the number 2 and it's in Title II, why wouldn't that be fair game? And would they have to overturn Iowa Utilities Board? Not you, not yet. You'll get your chance again. I want to hear from the guy who hasn't even said a word.
Well, I was just going to jump in and actually make that exact point and play a little devil's advocate here so Barron can have somebody to push back on so you can see him at his best. But yeah, so Section 230 was passed in the 96 Act. It was included and incorporated into the 34 Act, and 201B gives a general rulemaking authority to the FCC so they can pass rules and interpret the statutes within the Communications Act. The issue that you brought up is that Chevron deference has gone away. Loper Bright came in. We're not going to just defer to agencies, but that doesn't necessarily mean the underlying legal authority to interpret the statutes is gone. It just means the courts aren't going to give extra deference to the agencies. And I think we need to also be aware that a lot of these courts have started to, especially some of the district courts and lower levels, have tried to find ways to limit Section 230 in the past. And I don't think it's completely outside the realm of possibility that some courts could look favorably to these arguments and even with a kind of de novo review still come in and say, look, there's reasons to be concerned about this where the FCC has some authority. We're not going to defer to them, but we think this is a good reading of the statute. Now, my own view, again, that's kind of an absurd take. And I don't think there's anything in 230 that really indicates the FCC authority here. And I think the major questions doctrine you brought up is really the most damning for the FCC here. Obviously, besides some of the more basic issues, but one of the key components of West Virginia, which was the case that was kind of the relooking at the major questions doctrine, was that it's a long, extent statute that's been around forever, and all of a sudden we're finding new authority under it. And we've had it since 96 or 95. Barron can give the history, but we haven't interpreted it at the FCC in the past. We've never thought this is a grant of authority. It's been pretty clear that this isn't like a grant to the FCC. And now all of a sudden we're going to try to find a way for us to jump in and regulate how platforms moderate content. That just doesn't seem like it's in line there.
I'm moderating you. Hang on. So Josh, you want to comment on that? And then I have a question to add to that. Then I'm going to press play. Okay. Okay, so what if the FCC just comes out with a declaratory ruling, just saying this is what we think the statute means?
And I think,
and you courts now take a look at what we said. And by the way, my law firm, full disclosure, Cooley, this is not a shameless plug, but it kind of is, actually fashioned the early Section 230 common law. So a famous litigator, a wonderful guy named Mike Rhodes, who just retired last year, fashioned a lot of the early Section 230 common law. So what if the FCC comes out with a declaratory ruling saying, this is what we think this means?
I think it's two things. One, courts can look at that, and it's kind of similar with what Scalia did, where he made his 230 statements, and courts are like, let's use this to go after 230 in different cases. I could see, courts looking at a declaratory ruling. It has no necessary force of law, but they could still see it as a persuasive authority. It would only be the C2 provision, C2 provisions, and not the general C1 part of it. But that number one is something that they could do, but it's a kind of minor part of Section 230. The other thing I think more than anything is a signal to Congress. It's something that the Trump administration does a lot. They do things that don't necessarily have the force of law, but it's a sign to you should go pass a law to do something like this and kind of rally the troops.
All right, Secretariat's chomping here to get out of the starting gate. So do you want to?
Yeah, well, just first, let's clarify what it is that the Trump administration asked the FCC to do. So there are 3 immunities in 230. C1 is the immunity under which 98% of cases have been resolved. It's the one I quoted earlier, right? You're not to be treated as the publisher or speaker of content created in whole or in part by someone else. The first thing that the proposal would do is say that doesn't apply to content moderation. So it asks courts to overrule all of the case law, at least before TikTok versus Anderson. All of the case law has said that protects content moderation. So step 1 is that no longer applies to content moderation, and instead you have to go to C2A. C2A is a narrower immunity that says that efforts to restrict access to or availability of content that is, and Rob already cited this, that is considered to be blah, 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 or otherwise objectionable, that you are immune for those if you act voluntarily and in good faith. Now, people really struggle to see how those two things interact. It's actually not very hard to see. You can look at Barnes versus Yahoo. The Ninth Circuit explained this very clearly, which is that C2A is a belt and suspenders provision because Congress was really concerned with making sure that content moderation was protected. That, in fact, is the overall purpose of 230. C2A works differently from C1. C1 doesn't apply if you are responsible in whole or in part for the development of content. So, for example, if you slightly edit content, you may lose your C1 protection. If you then decide to take it down, you might be exposed to suit, except that C2A then protects you as a fallback provision. So C2A does different things, or it works in different ways from C1. So the Trump administration's NTIA petition is simply wrong when it says that the current reading renders C2A superfluous. That's just not true. They work together in tandem. But the first thing is, so not C1, only C2A, and then it makes C2A as hard to use as possible. The point of C1 today is that it functions not just as an immunity from liability, but as an immunity from suit. And what that means is that you, if you are sued, you can invoke C1 on a motion to dismiss that is relatively inexpensive, that can be filed before the cost and expense of discovery, which has been estimated to cost 90% of the total cost of litigation in federal civil litigation. C2A turns, especially as would be reinterpreted by the Trump administration, on hard factual questions. What is good faith? Did you act neutrally? Were you non-discriminatory? What were the categories of content that you moderated, et cetera, et cetera, et cetera? The point of the petition is to make that immunity as difficult to use as possible, and in particular, to make it impossible for a platform ever to invoke that immunity on a motion to dismiss. So what is currently an immunity from suit would no longer function as such. If you are sued for content moderation, as the Trump FTC is talking about doing, as state attorneys general are talking about doing, as many plaintiffs have brought suits that have thus far failed, would try to do, if you are sued under those provisions, you have a very difficult time using C2A, and that's the point. This is the war against content moderation, to make it as difficult as possible. The last and most important thing, and the reason we know that this can't be right constitutionally, is that the interpretation that the Trump NTIA petition put forward of C2A says we would protect some forms of content moderation, but not others. If you take down content because it's sexy, or it's violent, that's protected. But if you take it down because it's lying about who won the election, or because you ban dead naming transgendered people, or hate speech or whatever, that's not protected. Well, there's a name for that. That's content non-neutral. It's protecting some forms of speech and not others. If that's what Congress had passed, if Congress meant to draw those lines, that would be unconstitutional. And that's why that opinion, that interpretation will fail, regardless of whether the FCC has some ability to issue some advisory opinion, and regardless of what deference is given to that opinion under Skidmore.
Speaking of deference, Josh has been very deferential, so fire away.
To all of that, the only thing I would sort of add is I think this sort of highlights the bigger question here to the FCC's ruling is, like, even regardless of whether they can find that they have the authority to make this sort of ruling, is it desirable? Because if ultimately, if what they're trying to do is decide what is good faith, what is sort of objectively neutral, according to whom, the instant that you have an agency making that decision, that's now essentially the government making a determination of what is acceptable speech and not. That was something that the people who drafted Section 230 were consciously trying to avoid. And also, how is that not going to be used in an opposite way the next time that the next administration is controlled by the people on the other side?
So on that note, to build on that, for the crowd who aren't First Amendment experts, can you all please define the legal definition of censorship? Easy. Here comes
Where the government retaliates against speech that it doesn't like, expression doesn't like, and suppresses it. And that can be either content or the exercise of editorial discretion. So when
for speech too, not just suppresses, but for speech too.
Yeah, I mean, it's the government meddling in speech, period, which is what Republicans used to be against. Mike O'Reilly was unrenominated to the FCC merely for restating longstanding conservative opposition to government meddling in media, and for pointing out that the Trump administration's proposal was essentially for a new fairness doctrine. And for that, he was replaced by a lackey who helped to write the FCC's petition. And it's now sitting in judgment on that very petition.
So I'll agree with Barron's definition of censorship. This is when the government gets involved in online speech. I will somewhat disagree that there are still some Republicans that have fought back against this. And I specifically have to give kudos to Jim Jordan in the House, Rand Paul in the Senate. They both have legislation to essentially ban jawboning of private companies and telling them what content to take down. Barron is going to disagree with me.
Of all. He's the one who has, for example, waged war against the Global Alliance for Responsible Media, which was an effort by advertising companies to stand up for basic values of decency and say that they won't have their content, their ads sit next to that content. Jim Jordan abused his powers against that form of protected speech and made it possible for Elon Musk to sue them under a lawsuit that will never actually succeed in court.
Josh. Jeffrey.
I'll jump in here and kind of be more on Barron's side now, so we can be back there at that point. But
Commissioner Symington a lackey, are you now?
well, I'm not going to call Commissioner Symington a lackey, but I will say that yes, there's efforts to target the specific jawboning that we saw with the Biden administration. That's a good thing, but this administration is jawboning up like much more up front. The president will come out and tweet, "You are doing something I don't like. We need it." The broadcasters is a great example with the news distortion stuff, where Trump didn't like how the debates were covered. He didn't like a 60 Minutes episode. We should revoke CBS's license. And now we have complaints at the FCC that are open, that are looking at whether they distort the news. And I think that this is something that is much more upfront than what the Biden administration was doing. And honestly, I don't want to say more problematic, but it is a very problematic approach to speech. And it's going to happen with online platforms just as much as it's happening with everybody else that theoretically could fall under the administration's eye.
Okay, so content moderation versus editorial discretion. And this builds on my censorship question too. So in 2020, 2021, if you posted on Facebook that this virus may have come from a lab in Wuhan, you were taken down. Is that right? Should Facebook be allowed to do that?
They have a constitutional right to do that. Whether it's a good idea is a non-legal question.
Is it a good idea in your personal opinion? Don't hold back like you usually do.
No, it wasn't a good idea. But also look, in the Moody case, there was where this was alleged to be jawboning by the Biden administration. There was never any hard evidence that the Biden administration forced these tech companies to take down that content. The tech companies asked for certain categories or examples of problematic content. The Surgeon General provided that. That's not jawboning. Jawboning is when you use the power of government to force changes to speech, which is what this administration does all day, every day.
So the nudge, is that not a nudge for the Biden administration or any administration to say, hey, Facebook, really nice social media platform you have there. Be a shame if something happened to it. By the way, that stuff about the Wuhan lab, it's got to come down.
If that's what was happening, that's bad. And we should all be against it.
No, I'm not threatening you. I'm just saying I don't like that.
Yeah, well, we're all against that. The point is that the real jawboning is being done against content moderation. And the only reason that it's not recognized as such is because this administration has twisted the concept of free speech into meaning that everyone has the right to say anything they want on anyone else's private property, which is an idea that comes from the radical left. That was the idea of Jerome Barron in the late 1960s. And if you read the case of Miami Herald versus Tornillo, what you aren't seeing on the case itself is that the court was really slapping down Professor Jerome Barron, who was reciting precisely that theory. And what the court said is still true today, which is it doesn't matter what kind of monopoly power a newspaper had in any particular market, which was absolutely true then. There were newspapers that controlled the media landscape in individual markets all across America. And if they didn't run your op-ed, You didn't have your voice heard.
Okay.
That did not change the analysis. They still had a First Amendment right to decide what speech to carry. And the court said the exact same is true of social networks.
Got a question for Amy, but Jeffrey?
Yeah, I just wanted to jump in real quick and say that whether or not they should have taken down that individual story, the fact that they could, as long as it wasn't pressured from the administration, is a good thing. We want platforms to moderate differently because that's going to allow them to distinguish their service from somebody else. And that might draw customers in, that might drive innovation. There's a lot of reasons we want.
Okay, so how about Parler being forced out of business?
So it obviously gets trickier when you go toward up the
No, wait. Why is that trickier? Because it was considered center right?
No, there's a not a distinction, but as I understand it, there was more some of the infrastructure layer where there aren't alternative providers, but it's not so much that with the platforms, because you can theoretically just start a platform if you want to. You can go to a different platform if you want to. If there is getting to the point where there is one line of communication, there's no other alternative.
Just so folks don't understand. Sorry to interrupt, but this is how I wanted a little bit of Jerry Springer here, just a little bit. Sorry.
Jerry.
No throwing of chairs though. So Parler in part became popular because folks thought at the time Twitter was left-leaning and was eliminating dialogue from conservatives. So Parler became a darling of the right. And then there was a big backlash against it. This was during the Biden administration, and it was gone suddenly because Oracle or somebody took them down. They deplatformed them. And is that right?
So if I remember, didn't they come back up at one point, or am I thinking of a different Senate right, or like a right-leaning app? Maybe it was Gab or something. But there's alternatives that you could go to and find a different cloud service. Like there's alternatives out there, and as long as you're not forcing, like the government coming out and forcing them down, there's a distinction when it's a private company doing it.
Okay.
Yeah. Let's talk about Parler. Parler refused to do basic content moderation, like using photo DNA to identify known images of children being raped. Parler's solution was, we'll have a community jury, and if the jury decides that content is unlawful, then we'll take it down. Parler turned a blind eye to the flow of child sexual abuse material, just to give you, because free speech, because they didn't believe in any content moderation whatsoever. And it's for reasons like that Google and Apple refused to allow Parler's app in their store, and that other infrastructure providers refused to do business with them. I mean, this is what it means to have a truly unmoderated network. And this is true not just of Parler, but of other services.
You're not that libertarian.
I don't use that word anymore. I don't even know what that means. Okay. I am, look, the internet, absent moderation, the internet would be a vile, disgusting cesspool that we would not want to use, which is what Parler was. It's what Gab is. It's what Truth Social and other services like that are. The unmoderated internet is humanity at its absolute worst.
Are there any members of the press here? I hope you're getting some good ink. Getting some good ink? Okay, good. Yeah.
And
can't type fast enough. Slow down, Baron. Hang on, slow down. Drew's got to write this.
And one of the reasons that those services don't flourish is that advertisers don't want to do business with them. And when advertisers didn't want to run their ads on X, what did Elon Musk do in response? He sued them.
Okay.
And he sued them because Jim Jordan had already weaponized his office to wage war against the Global Alliance for Responsible Media.
I take it you're not getting a Christmas card from Jim Jordan this year, or sending him one. All right, quickly, anyone want to comment on that? Because I want to ask Amy a question. All right, so please explain the Net Choice Supreme Court decision from last summer. Is that a Section 230 case?
So first, the two
The answer
cases.
is no, it's not a
The
Section
answer is
230
no,
case.
it is not. So the two cases he's referring to, of course, are Net Choice versus Paxton and Net Choice versus Moody. We successfully challenged these state laws, Texas and Florida. They both attempted to override private platforms' editorial discretion. So again, not a Section 230 case per se, because let's be clear, even if Section 230 goes away tomorrow, there's still the First Amendment. So if you take away nothing else from this panel, remember that any sort of legislation that narrows the scope, that repeals it, that sunsets, there's always the First Amendment, and platforms will always have that ability to moderate content how they see fit. So we believe it was a huge win for us last year at the Supreme Court. I would love to say that, lawmakers have looked at the Supreme Court ruling and they have backed off and shied away from Section 230 reforms. Obviously, that is not the case. I think the ruling has been misconstrued a bit, but essentially, again, social media, the First Amendment doesn't stop just because the tool is social media.
Anybody want to comment on that?
TikTok versus Anderson relies on the net choice discussion of the First Amendment rights of platforms, right? It's important to note, as Amy said, that the net choice case says nothing about 230. The Third Circuit in the TikTok versus Anderson case somehow pretends that the net choice case was about 230 and comes up with this insane, essentially gutting of 230 to say that the statute doesn't protect curation merely because curation is protected as a publisher function under the First Amendment. It doesn't make any sense. The TikTok versus Anderson case also relies on the insane, deranged misreadings of 230 that Justice Thomas has engaged in repeatedly based on issues that were not before the court in the cases in which he wrote those opinions. Those are just him writing essentially op-eds for Fox News without the benefit of briefing.
You get that, Drew? Okay.
I'm holding back.
This is the filtered version of Barron. This is why I love having him on panels. Okay, let's talk about the economic effects of Section 230. So Josh and Jeffrey, you want to talk about that? Like, this is now almost 30 years old, it's 29 years old. So February 8th, 1996. You remember that day? I see Paula. Is that you, Paula? Hi, Paula. Did you write Section 230 when you were with Senator Hollings? No, she's disavowing too. Chris Libertelli, did you have anything to do with it when you were Chairman Powell? Now, did he want to do anything, Chairman Powell, at the time on 230? Because it was, okay, no. Sorry, everyone's disavowing. But go ahead, tell us about the economic effects of Section 230.
Sure. I mean, we've already covered it in passing, but I think one of the things that makes Section 230 in a lot of ways sort of an enhancement of the First Amendment is the way that it covers economic activity and not just speech. You know, Barron was already mentioning the fact that one of the reasons that some of these platforms were moderating some of the stuff that they were is that they rely on advertising revenue in order to monetize their platforms. Advertisers are very picky about what sort of speech their brand is being associated with, and so that provides certain economic incentives for different platforms to make choices about what kind of advertisers they're going to be attracting. That's going to necessarily upset everybody whose speech they choose not to feature. And that's why I think the most important thing is that there will be a variety of platforms, experimenting with different methods of content moderation. They'll attract different revenue streams, different types of audiences, because ultimately there's no content moderation strategy that's possible that will appeal to everybody.
Jeffrey, competition. Imagine that. Jeffrey?
Yeah, I think the other point is what Barron brought up earlier. It's essentially, getting a motion to dismiss, getting summary judgment, getting the lawsuit out immediately. And that's going to save companies a lot of risk. It's going to alleviate risk and save them money. Well, if you're an investor and you want to, invest in a startup, if you have this added risk that's coming, because now every decision could theoretically lead to a court case, maybe you don't invest in that new company. Maybe you don't invest in a new app that's coming through, because basically everybody has third-party content these days. And as that happens, you're just going to see some of the incumbents get entrenched. So if the goal from folks is to say we need to go after big tech, I'm not so sure that going after Section 230 is the best strategy to do that.
Yeah, and just as if to illustrate that, there's actually a great study that was done that showed that investment in tech startups, particularly that hosted third-party content, you can see a graph where the investment capital in the U.S. spiked dramatically after Section 230 was passed compared to investment in other areas such as Europe. And that's not a coincidence, because the Engine did a really great study on the cost of litigation and how much it costs even just to get the discovery in one of these cases. If you have to defend yourself against, a defamation suit, the average startup only has like $55,000 of sort of income laying around per, I think, month it is. And it takes more than that just to get past the first couple of stages if you don't manage to get a case dismissed under Section 230. So, anything that you do to sort of limit Section 230's safe harbor there, it basically can wipe out the startups and the smaller companies and just advantage the incumbents in the market.
The point here isn't just that litigation is costly, it's that it is uniquely costly. We have a unique asymmetry between offense and defense in the United States because litigation is expensive, and we are alone in not having a loser pay rule, which means there's no disincentive to bring frivolous litigation in the United States. And ultimately, this is not about the companies, it's about users, because it's users who would suffer and users who would lose the opportunity to speak without those benefits.
So excellent. I want to build on some of that. By the way, I see yet another author of the Telecommunications Act of 1996 in the back, Colin Kroll. Everybody, big round of applause. Did you write Section 230? Yeah, okay. The first person to actually own up to it. All right. Thank you, sir. When he was with Congressman Markey at the time. So this is unscripted, and I didn't give a heads up. 4 minutes left, but I think this panel can handle it. Any audience questions? Drew.
No, seriously, this is a great discussion, but it's a little bit one-sided and not.
Yeah, I've tried to be devil's advocate a couple times.
You say that's bad because it's probably the right side, but given the prevalence on the other side, given how much energy there is coming from those who think that censorship is not censorship and the reverse is censorship, what's the kind of strategy? Like, what's the political strategy for getting us back to a world where conservatives did care about free speech?
Impossible. All we can do is beat them in court. Their brains have been rotted out on this topic. It is impossible to have an honest conversation with them. And we did, I suggested multiple people for this panel, all of whom declined, because they're not willing to discuss the merits of this issue, because their positions, when you actually look at them, are ridiculous.
Anyone want to?
Yeah, it's tough to have these discussions with lawmakers because you raise the constitutional issues. And honestly, some of the feedback we get, fine, sue us. You know, this is what our constituents have called for. It plays well where they're based. You get a number of these messaging bills that sound great, but have no basis in factual law. And yeah, I tend to agree with Barron that it's really hard to do.
Yeah, the only thing I would add to that is I agree. I mean, I think that in a world where the arguments were happening in good faith and people were actually taking a sober look at just how the law applied here, there might be a world in which a rational discussion about like minor ways you could tweak Section 230 could happen. I don't think we're living in that environment right now. I think right now most of the energy is just people wanting to punish the tech companies for their perceived transgressions, some of which are real, but I don't think this is the avenue to be doing that. And unfortunately, on the left, a lot of the energy is people wanting to force platforms to take down more content. And as long as those competing tensions are what's motivating the energy in this sphere, there's no real rational conversation to be had.
And to build on that, you get legislation every year, dozens of bills from the left and the right in Congress, right?
Yeah. Nothing's going to pass. I mean, the only thing that will happen is the FCC will issue their rule. This is the one awkward thing about this. It is not clear that rule can be challenged. So directly, in other words, it may have to get litigated case by case. So we may end up in a situation where this throws the lower courts into confusion. And that's their goal, right? Their goal is to break content moderation and to make it to get the Supreme Court to finally take the case that Justice Thomas wants to take. And ultimately, this is about the First Amendment, because what they want is to favor some forms of content moderation and not others. And that's the kind of picking and choosing among speech that the First Amendment forbids.
So did you get that? The takeaway here is there's only one awkward thing going on here, right? So did you get that? So next time you do a 2:30 panel, could you please start it not at 3:30, but at 2:30? Okay, thank you very much. All right. Could you give this panel a big round of applause, please? Thank you all for coming.